Okay. So to start us off, Sam, why don't you just tell us a little bit about your background and experience and what prompted you to get into the race for the county attorney's office?
Sure. So I've been a lawyer for going on 12 years, got my education at Buena Vista University and the University of Kentucky College of Law. After I graduated law school, I still wanted to be Garth Brooks. So I moved to Nashville, Tennessee, where I practiced in criminal defense. And I met up and started working with a woman who does environmental work, primarily Clean Water Act litigation against landfills. So worked with her for those 5 years, and in the middle there toured with a country singer and helped manage his career for a year and a half, 2 years. Moved back to the Dubuque area in 2016 and joined Reynolds and Kenline. It's a law partnership here in town. After 2 years there, I made partner and practiced primarily in personal injury, criminal defense. I took on a landlord-tenant class action a couple of years ago and have had some civil rights work and employment work like that. The reason I got interested in running for county attorney is because having seen it on the defense side for years in different areas and different jurisdictions, seeing it done in some places really well, where a really clear vision and a really clear team attitude exists. I knew that Dubuque could do better. And in the last few years, I felt as though we weren't seeing consistent results. We were starting to see some more drift into inconsistency, and started to notice a lack of morale in the office, kind of a loss of that team atmosphere that I'd experienced when I was an intern in that office, and thought I could make a change. So that's my goal, is to focus on teamwork and consistency.
I missed that. So you were an intern at this in this courthouse?
Yeah. So in 2009, while I was a third-year law student at Kentucky, or second-year law student at Kentucky, I was a summer intern. So I came back up to Dubuque for the summer and got to work with Bob Richter and Alicia Stack and Ralph Potter, and handled a misdemeanor docket and even tried a couple of jury trials that summer.
Okay. And obviously we've seen a lot of turmoil in the county attorney's office. So tell me a little bit. I guess first of all, let's
I'm sorry. I did lose you right there for the word turmoil.
Okay. Let me step back and ask. So you primaried an incumbent, and I guess one is do you think that the office should have a political connection to it, as far as should it be a partisan office at all, and why do it that way as opposed to running independently, or was the Democratic, the D behind your name, more telling than that?
So I don't know if this is a sort of office that needs a political affiliation. I've said before that I think it does provide a guidepost, so it kind of lets voters know a little bit of what you're about. Certainly, I think when there's an R next to someone's name, that has a different connotation than a D next to someone's name, and people can make their own judgments after they've met the candidates. I ran as a Democrat because I am a Democrat. That's not always been the case, but since 2007, I've been a Democrat, and I'm not ashamed of it. I'm proud of it, and that's why I ran the way I ran.
Mm-hmm. So, as I was starting to say about the turmoil in the office, what do you think needs to be done to kind of restore credibility from a community perspective in that office, whether it be you or whoever the next county attorney is?
I think it all starts with working as a team. That office needs to know that the person standing next to them has their back, and the person who's the elected official has their back. That when there's hard work to be done and hard decisions to be made, they're going to get input, but the buck stops with the elected official, right? And taking responsibility for some of the maybe screw ups and some of the things that maybe fell through the cracks, that falls to the elected official. And the people in office need to know that when things go wrong, the guy at the top is going to take it. And he's going to stand behind us when things go right. And he's going to, he or she, I mean, if a woman were running the office, whoever's running the office is going to be there as a teammate, not as a, someone shouting out orders or talking down to folks, but really working hand in hand to say, look, I'm here with you. We're working together. We are a team. And I think that's first and foremost.
Do you know what the status is currently with staffing in that office? Are there still, we reported on a lot of people leaving the county attorney's office. Is staffing going to be an issue?
Well, when you say staffing, do you mean attorneys or support staff or paralegals?
Yeah, I guess I was thinking of the attorneys.
Well, I know there's been 2 recent hires. An attorney named Sharon Halstus was hired recently as a felony prosecutor. I think my understanding is she's now handling some simple misdemeanor stuff instead. And then also Amanda Lassance was recently hired from Jackson County, where she'd been a prosecutor for several years. So I feel like, and if maybe I've misread their most recent letterhead, but I feel like we're getting close to a full staff. I've been a big proponent, and probably because of my own experience, of having interns in the office during the summer and over winter break. I think we can use those people, those interns, to serve as kind of a feeder system to the office generally.
Okay. And if elected, what kinds of changes, if any, would you institute in terms of the daily business of the office?
So I see the role not just as, chief trial attorney, that's part of it, but I see the role really as a policy setting role, because one thing we know doesn't work is just telling 9 or 10 different attorneys to say, hey, go out and do justice. Whatever that means to you, go do justice. That's not effective. And to be unclear is to be unkind. So let's give those prosecutors really clear goals and guidelines. And what I would start with is to say, look, if we're talking about violent offenses involving weapons, our presumption is that someone's going to serve some time in custody. Okay? Those are the types of crimes that we just can't tolerate as a society. And as we work down from that violent offenses with weapons to, violence without weapons, and then property crimes, and then maybe drug possession, those sorts of things, we need to have guidelines for the prosecutors to follow. And the way I would treat it is to say, look, Iowa has this incredible prosecutorial tool called a habitual offender, and it's for folks who commit multiple felonies. But right now it's used kind of as a bargaining chip. So they throw this habitual offender on and go, hey, you're going to get 3 to 15 years in prison if you're found guilty. But that doesn't make sense for everybody who's got a felony record, right? We should use it specifically. And when we use it, we should use it to the end, not as a bargaining chip. But look, we are going to pursue a habitual offender against you because you have a history of violence. You have a history of using weapons in our community. You have a history of felony convictions. If we go kind of what I consider the other side of the spectrum in the criminal world to your more like simple possession of marijuana, I think we can have a really simple policy that says, look, we're going to treat that in a way that's sort of akin to the way public intoxication or minors in possession of alcohol has been treated. We want you to stop doing it, or we want you to educate yourself, and we want you to make amends. And I think we don't do that by saying, all right, simple possession of marijuana, definitely get a conviction, or put them on a deferred judgment for 2 years so it's wiped off their record in 2 years. Instead, I say, let's put some skin in the game today and either take a drug class, give us a clean year analysis showing that you're not using anymore, or do some community service so that we can say, look, you've paid your debt to society. We're going to dismiss your case at your cost. And that way prosecutors know, okay, simple possession of marijuana comes in, that's the way we treat it. Theft of property comes in on a first-time offender, we're looking at a diversionary program. Domestic assault involving a weapon comes in. All right, we're going to be seeking incarceration in this case. But to give those guidelines to prosecutors, I think is the number one job of the county attorney.
So do you think now, I mean, obviously you think that's not what's happening now. We hear a lot about the plea deals given out and over a range of different types of crimes. How do you feel about using that tool?
So we don't have the capacity to try every case. We've got 2 district associate judges and 3 district judges. If we tried all 3,000 cases that have been handled this year, we're going to be in trial forever. We're never going to get to them without plea agreements. So definitely a tool we need, but we need a consistent message to what those pleas look like. And I know a lot of people talk about, well, we need transparency in that office, and what does that look like? One thing I've suggested is that when a prosecutor is doing a plea, what typically happens is the defense lawyer writes up the plea as they've discussed it, and the public doesn't know what those discussions look like. So all the public or the TH sees is the plea was to this crime, and this is the punishment, right? I think if we, as prosecutors, just filed a very brief sentencing memorandum, and this is something I've done as a practice as a defense lawyer when we have contested sentencing, to say, Judge, if you're going to be the person sentencing this person, I want you to remember that this person's 19. He's got no criminal record. And, he's banned himself from the casinos if that's his problem, or he's taken a drug class if that's his issue, or he's in mental health counseling if that's the concern for that person. I don't understand why the prosecutors aren't doing the same thing to say, Judge, we've submitted a plea agreement, and here's just a brief memo. We have not been having any contact with the accuser in this case. If we go to trial, we're concerned that we'll have a weak case, so we've reduced it from A to B. Judge, we're under the impression that this person has been involved in mental health counseling, is doing well, and that's why we're recommending probation under these circumstances. That way it's in the record and it's not just a blank. The plea went from the most severe to the least severe, and he went from, something we all thought should be a prison sentence to probation. But to give some context through, a 2-page little sentencing memorandum provided by the state, I think that just provides some transparency so folks can say, well, these are heinous crimes that got reduced. Well, the reason they got reduced is we didn't have somebody who come to testify. The defendant had done a really good job over the last 6 months to improve their station in life.
I'll ask you one more quick question and then let my colleagues jump in here. But if you establish those guidelines for maybe when it's appropriate to reduce the charges or reach a plea agreement, are those things, do assistant county attorneys need to run those decisions by the county attorney, or we've got guidelines, so you go ahead and run with it?
I would hope they wouldn't have to run it by me.
Mm-hmm.
I would hope that we can do a good enough job of instilling kind of our prosecutorial philosophy and values that folks don't feel the need to run every case by the county attorney. That creates a huge inefficiency. Additionally, I would want people working in teams within the office. One thing I floated to the county attorneys union was to say, look, we need a group of folks who just want to go out and handle big cases and trials. Because the reality is not every attorney wants to take a case from arrest to trial. So we shouldn't force people into a position where they're not set up to succeed. We've got some attorneys in that office who'd be really excited to just focus on discovery, focus on getting cases pled. And when they can't, you hand it over to a team of lawyers who really want to get in the courtroom, get in front of 12 jurors and make an argument. And I think if we apply that team approach as we're going through the plea bargaining process, instead of coming to me if I'm elected, they can turn to their colleague and go, hey, on that Smith case, what do you think about this now that we know they've gone through treatment, or they're doing, they've got a new job and they're living clean, or whatever it might be, right? But to run that by each other internally on a team, as opposed to send everything up the chain.
Okay, thanks.
So Sam, I'm curious, when you started to think about running for this office, talk a little bit about the thought process you went through. Who were the key people that you reached out to for advice and counsel before making the leap?
So because I was in private practice, my firm had a policy that said if you leave practice, you need to give 6 months notice. And I knew that I wasn't going to be able to fulfill my duties as a partner with that office if I was running a campaign full time. So I really started thinking about it, I guess, in February of 2021. And then after the Ellison case, I kind of really got serious about it, I think.
And that was the Loris Boulevard.
Loris and Locust, yeah. Yep. And our office handled that case. So after that, I kind of reached out to Denise Dolan. I spoke with Chris Corkin because she's just got a wealth of knowledge in that office. I talked to a handful of lawyers in town who I respect, and reached out to them directly and said, am I crazy for thinking about this? Of course, I talked to my partners at the time and got their feedback. But I made a decision, I think, in May to give my 6 months notice. And that's how I left the firm in December of 21.
And since then, have you reached out to any of the surrounding counties to talk to their county attorneys and said, gee, what am I getting myself into if I get this position?
Probably not in that way, like what am I getting myself into? But I've talked with Sarah Davenport down in Jackson County on occasion, not regularly, just kind of about the process of campaigning, because it's a first for her too, is my understanding. And I've talked to John Bernaw out in Delaware County a little bit about how he handles the job. Nothing super in depth. I have, spent some time talking to Ralph Potter about how he operated the office and his sort of philosophies.
Great, thank you.
Yeah.
Dan, are there any specific examples that you've seen the county attorney's office handle within the last few years where you would say they definitely, in my mind, handled this differently than I would have? I would have been either more lenient or more likely to plea or plea down, or I would have been more likely to take it, not plea it, and down and take it to prosecution or whatever. Are there any specific examples that you think stand out in your mind?
Well, yes. The one that jumps out to me right now, and because it's kind of, I guess it's sort of still in the news a little bit, and it's still a case that's active, is the Sean Turner case, where you've got an individual on probation, on bond, and commits a very serious violent felony involving a weapon. I'll give you a little bit of context for my thinking on this topic in particular, because I think probation and bond are important. They're the court telling someone, we're going to trust you to behave. And when I was in practice in Tennessee, there was a state statute that said, if you commit a felony while on bond for a felony, your sentences must be run consecutive. You don't get concurrent time. I hated that as a defense lawyer, right? Because it made me have really difficult conversations with clients. But as a prosecutor and as someone who cares about community safety, that makes total sense to me. Like, if you're committing new crimes and we've already told you we trust you to behave, you've not only broken our trust, but you've done something else to hurt another person. And I think in those situations, that would be my approach, is to say, look, you're on probation and you commit a violent crime, it's not going to be run them concurrent. And I'll pause because I don't want to jump to the next conclusion. I would take a much different approach to someone who's on probation for it's shoplifting and then gets caught with marijuana, right? I don't think that's something that says, oh my goodness, we've definitely got to crack down here. I look at it more as terms of violence. Another case, I don't want to use the name. I'm I'm sure y'all can figure it out if you dig a little bit, but I represented a man who wanted to sue a bar for over serving an individual. This individual bit off my client's nose. And again, this defendant was on probation out of Jackson County, and he did serve some time in jail because he couldn't make bond. But ultimately, he was put back out on probation in Dubuque County. And like those sorts of offenses, when you're on probation, when you're on bond, just strike me as the sort of thing where you kind of had your crack at it. Let's use that probation with its lower standard of proof to move that case out and now focus on the new charge.
Great, thank you.
The thing that you mentioned, Sam, as far as the having to run consecutively versus concurrently, is that something that you can just employ as a policy, or would that require a change in sentencing law?
So as a policy in the office, we could say, look, if someone commits a violent felony while on bond or probation, our policy is the only offer they're going to get are consecutive sentences. If defendants say, forget it, I'll take it to a judge and see what he or she does with it, well, that's the judge's prerogative at that point, right? And we're going to make a coherent and straightforward argument on why the judge should impose consecutive sentences, but it's up to the judge. I can think of a case I had a couple of years ago where my client had a bench trial, and he was convicted of domestic assault. And while he was in custody, he punched another inmate in the face, breaking his jaw. And I told the client, I said, I think you're in big trouble and big chance of consecutive sentencing in this case, because if a judge looks at it and says, you couldn't even behave in jail, fortunately, despite being convicted of both offenses, fortunately for my client, the judge ran him concurrently. But if I were prosecuting, I would argue against it. I would argue, look, these are, felony on felony. Let's make them consecutive.
I've got a question. So you talked about your background, and a lot of your experience is you talked about on the defense side of things, and that's something where you've got spent a lot of your time. How do you kind of see yourself stepping into a prosecutorial role? I mean, how does that defense side, impact that? But also, how do you kind of switch to arguing the other side of the case, and how do you see yourself doing that and making sure that's consistent?
So I will say, as a private lawyer, I kind of get to pick and choose the sides I want to represent, right? So I don't represent like insurance companies, for instance, because I don't think I could do a great job of asserting their interest in a courtroom. I wouldn't sign up to be a prosecutor if I didn't think I could do a really good job of asserting the county's interest in a courtroom. And I don't think it's that far of a stretch to go from, showing empathy to a defendant and arguing their best case in a courtroom, to showing that same empathy to a victim of a crime and ensuring that their voice is heard and appreciated, either at trial or at a sentencing hearing. And I see my role as a prosecutor not of getting convictions, but of seeking justice. And, some people think, well, civil lawyers are just out for money, but I feel like I have a sense of what I think justice is, and that's what I try to get, for all my clients. Sometimes it's just a harder uphill climb than others.
I'm going to jump in here. So, obviously, this is only going to get more and more attention as election day nears. Three-person race, got three pretty different perspectives early on in some of the discussion points. One thing that so I'm kind of curious about how you're conveying to voters how you're different than your opponents, and particularly responding. I know one of your opponents is kind of painting you a little bit as maybe soft on crime, or overly focused on kind of restorative justice and some of those programs. Could you kind of explain to me your response to that, how you explain to voters where you fall on all that?
Yeah. So I've knocked on about 4,000 doors so far, and I spend very little time talking about the other two individuals running in this race. I'm running on my own merits, and I think that my message of consistent results that when you hold them side by side make sense in context, and employing a sense of teamwork in that office has really resonated with voters. Folks don't like seeing, as Amy put it, turmoil. They want to see folks working together to a common purpose. So that's what I've talked about. I haven't spent a lot of time talking about the other guys running. And look, I'm not going to disparage folks for as a part of my campaign.
Well, as far as the restorative justice piece, is that something that you're talking quite a bit about, or sharing with those as you're knocking doors?
Yep. So what I often tell people is I start with like the same way we talked about with violent offenses involving weapons, but I always remind them, look, we need avenues for folks who are youthful offenders, first-time offenders, and committed, property crimes. We need avenues for those folks to be able to make amends without having something hanging around them for the rest of their life. I really believe in those second chances, but I believe in second chances with some skin in the game. So if you think about somebody today who gets a deferred judgment, right? And deferred judgments aren't going away, but what a deferred judgment is somebody who says, behave for 2 years and we'll wipe this off your record. Behave, keep out of trouble, and we'll wipe it off your record. What I prefer to see is say, hey, if in the next 2.5, 3 months, you can get a job, you can treat your addiction issues or start working on addiction issues, you can start focusing on your mental health, and you can make amends to the person whose property you damaged or, whose things you stole. If you can make amends to that person, I'd rather have your case dismissed for you in 3 months, because I know you put the work in and you put the skin in the game to earn that reward. Like, I talked to a guy just recently who said, well, you're talking about personal responsibility. That's not what Democrats are about. I said, well, sir, I'm not going to be giving away free hall passes. Like, my plan is you put some skin in the game and you get your reward, a dismissal, sooner. Or we stay under the current system where it's a deferred judgment. You hope the person stays out of trouble, or, in a lot of people's minds, don't get caught. And then it's dismissed. I think we can make better change by saying, no, put in some hard work right now, and you'll get a dismissal sooner. You'll get your record clear. And look, maybe it's not always a dismissal. Maybe it's put in the hard work right now, and you've earned a deferred judgment. Right? Maybe it's somebody with a little bit of a more checkered past that we say they're ready for change. You know what? Put in a little hard work now, and instead of spending 180 days in the county jail, we're going to give you a chance on formal probation. But put in the hard work up front. I think putting that skin in the game is so valuable. And I'm sorry, get me all fired up. While I'm thinking about it, I just want to point out, like, our OWI prosecution model hasn't really changed much in the last decade or so, but it's very consistent. It's very consistent, which I think is great, because people and attorneys know what to expect when somebody walks in with an OWI, right? The one thing I would add, and I think it's hugely valuable, because the more tools someone has to make change, the more likely they're to make change. I would strongly encourage that we include in all plea agreements a requirement that people go to a victim impact panel. And that's where you hear from people who've been victimized by drunk drivers. And sometimes having that opportunity can, might be more effective than sitting through a DUI class, but hearing from actual victims about the potential for human injury and property damage might make someone think twice the next time they start their car. Additionally, and I've seen this a lot in other jurisdictions, we use it extensively in Tennessee. I know they do it in Black Hawk County, but for second and third offenders, incorporating some mandatory AA. And look, you might call that restorative justice because we're making you do things, but I think it's important that folks take the steps to make their own change. So on that particular type of offense, I would want to lend into that direction as well, just to give people more options to figure out what works for them as far as making a difference.
As far as some of the really high profile cases that come to the office, in the past you mentioned Chris Corkin, and she was kind of the go-to in the office when it came to murder trials, things like that. What is your experience in that area? Have you handled murder trials? More recently, we've seen the Attorney General's office step in the most recent case to take the lead on that. What's your experience been with the really high profile cases?
Yeah. So my first big trial was on an aggravated child neglect case in Nashville, Tennessee. And that sounds like a lesser charge, but it carries 15 to 25 years to Class A felony. It got broad press, had a cover story in the Nashville Scene, was on several news pieces, and the press followed it extensively. Got a not guilty verdict, so I was very proud of that. So I've handled big cases even when maybe I shouldn't have been handling them. I'll be honest with you. That case, I maybe shouldn't have been handling it when I was assigned to it. But I learned a lot, and I got a great result. I have not handled a murder case.
Okay.
I've handled attempted murder, but never a murder case. I did work closely. I wouldn't say like to the point of filing an appearance in a case, but I worked closely with Ben Bartles and Natalia Blaskovich when they tried the Ellison case. Part of our atmosphere was working as a team. So when they were preparing their opening and closing statements, we sat down together and said, nope, don't use that word. Let's use this word instead. Let's say it this way. Let's focus on this evidence. So I think it's important to incorporate a team because, murder cases are too important to just say one set of eyes is plenty.
How does that work then? I mean, when like we saw the the Attorney General's office come in the most recent case here, murder case, how does that happen? Is that something where the county attorney reaches out for assistance, or do you know?
My understanding is it's if the county attorney wants that help, they're welcome to reach out to the state for that help. And I've talked with police officers, and they've said, look, if it's day one and you get 2 murders, we want you to grab the AG. We want to make sure that those cases are fully staffed. And that's an obvious goal for everyone, right? We don't want murder cases just kind of drifting out there. We need people dedicated to them. And that's why I think having a team that's focused on trials that can absorb those type of cases is really important.
Sam, tell us a bit about your experience as far as supervising staff, or do you have experience supervising attorneys?
Yep. So at Reynolds and Kenline, we kind of all take responsibility for ourselves. But what I would talk about and tell you is, we take turns as managing partner, and really what that means is scheduling our meetings and signing the checks for the day. It's not a super managerial role, but we do make decisions on staffing and staff conflict. And more importantly, my experience has been working on it as a trial team. So for instance, I've worked with Todd Klapatowskis and Natalia Blaskovich both really closely as a team. So when I'm the lead attorney on a case and we're the 3 of us or 2 of us working on it together, it's figuring out how to delegate tasks in the scope of a trial setting. As far as leading a team of professionals as big as the county attorney's office, I think it just starts with figuring out what people are doing, what their skills are, and how I can help set up I don't want to say chain of command, but set up a structure so that not every issue has to reach the top, right? So one thing I've seen in the last 4 years is that we don't have a first assistant. So when you mentioned Chris Corkin, forever, anyone on the criminal side just said, oh, talk to Chris, don't bother Ralph with it. And I think having someone in that first assistant spot is really important to, work with those staff issues, work with the attorney's issues. So as they're coming up, we've got somebody there, and maybe two heads are better than one as we kind of sort through those issues.
Sam, I know you mentioned the current staffing to the best of your knowledge. Do you know at this moment if there are any staffing needs, either in terms of open positions or needed expertise, skills or expertise?
I believe we've got both victim witness coordinator positions filled right now. I believe there is still 1 or 2 openings for paralegal secretarial staff, but that's what I'm aware of at this point.
And since you left Reynolds and Kenline, you've just been sole practitioner, or what kinds of work are you doing now?
So I haven't taken on, since announcing my campaign, any new criminal cases. I've cleared up maybe the dozen or 2 dozen that I've had. I have taken on, I think, 2 new civil cases, but I'm not actively taking on new cases until I know what my next year looks like. I don't think it's fair to clients to begin building that relationship just to have it cut off. I have had 3 trials this year and 1 missed trial. We had a juror who caught COVID, and that case will end up being tried next week. So no campaigning for me, just a jury trial next week.
So another big responsibility of the county attorney is being the attorney for the county. What
Absolutely.
kind of experience do you have in that area? And we've seen, I guess, several issues come up in the county this year, and the county currently doesn't have an HR person, doesn't have a public health leader. We have a lot of positions that need to be filled. So can you talk a little bit about what you would bring to the table there?
Yeah. So as it pertains specifically to employment and HR, I've handled a handful of employment law cases. I feel fairly comfortable in that area. The one thing that I'll say, I am not, and I've not had a lot of experience in the transactional type legal work. So, transferring property, putting an easement over a piece of ground. Those things don't come across my desk very often, so I don't have a lot of experience in them. But I know that. It would be my goal to have somebody who is skilled in transactional work to come in and either train staff or join staff to take on the lion's share of that work. And I understand that several years ago, an assistant county attorney was hired to handle simple misdemeanors in the county's business with oversight from the county attorney. And that assistant county attorney has expressed to me that they're still interested in taking on that role, but have not been permitted to. I would want to empower somebody to say, look, I need you to attend the Board of Health meeting so we know if we're following the open meetings laws and if they have questions about what comes up. I need you to attend the zoning commission meeting so we're following the law and following the procedure in that area. Look, it's not a passion of mine. And I think I know enough to say, I'm not going to be able to give 1,000% energy to those sort of transactional issues that I can on the criminal side. And I want to be able to be a support for the person who is assigned to that role. But I don't think it's the best use of my talents or skills to spend all my time on county commissions and real estate transactions.
So you're saying that would be somebody from within the county attorney's office, though, as opposed to having to hire from outside, or did I understand?
Well, the person I've spoken with is currently in the county's attorney's office.
Okay.
Yeah. And I've talked to a handful of other folks about, if that's something they might be interested in or not, but nothing solid.
You mentioned the domestic violence cases in passing, and I think in one of your explanations about sentencing and kind of where you would draw the line on that. Can you tell me just kind of your take or your observation on how domestic violence cases have been handled by the county, and whether there is a need to do anything differently there, or changes that you might foresee?
Well, because I haven't been taking on new criminal cases, I don't have a great sense of what sort of procedures the current victim witness coordinators are going through as they're working with victims of domestic violence, or any victims for that matter. I know the way it used to be several years ago, and I was very involved in criminal practice, or even a year ago, when we had a pair of victim witness coordinators who did a great job of not just informing and updating victims, but really standing with them and ensuring that they were appreciated and fully apprised of what was going on with their case. So I think we have to really rely on, especially in domestic violence cases, the work that victim witness coordinators do. On top of that, this is another case where, if we're working out plea agreements, a simple sentencing memorandum from the state might go a long way towards clearing up why, my neighbor down the block got 30 days for domestic assault and some other Yahoo got a probation sentence. I think that's another area where those are tough cases, not because the facts aren't there, but we all understand that most victims of domestic assault don't just want to rush out and have the police involved in their life tonight. There's a stigma associated with that that's really hard to break, but we have to work at, and we have to work through. And it means spending a lot of time with those victims to ensure that when they walk into a courtroom, they're ready. They've got that bravery built into them. And in my private practice, I spend a lot of time at clients' homes. I was at a client's home last night preparing for that jury trial because I know that she is comfortable there, right? So part of that is not just saying, to a domestic violence victim, hey, come down to the courthouse at 3:00 and be there and we'll talk about it. Like, it's making it really convenient for them. If that means they can text with the victim witness coordinator, that should be an option. If they prefer email, that needs to be an option. But we need to make sure that victims get the support they need so they feel empowered to go into a courtroom. That's why you lose domestic assault cases if you lose them, and if you're losing them, but you lose them because the victim isn't bought in.
Well, we're getting close here to the end of our time. Any additional questions for Sam? Or Sam, is there anything that you would like to say that we haven't asked you about that you think might help us in understanding what you bring to this role?
No, I'd only reiterate, I think we need an office that works as a team. We need an office that works together with a common purpose and a clear goal of what justice looks like.
Mm-hmm. Well, I really appreciate you meeting with us and sharing your thoughts on these things. And thank you for your time. Wish you luck the rest of the way.
Thanks for having me.